Okay, this is the memorandum of Respondent Minnesota DFL, Democratic Farmer Labor Party, opposing the petition. On November 6, 2012, incumbent Representative Betty McCollum won 62% of the votes, and on January 3, 2013, commenced her 7th term in office. Petitioner Steve Carlson, who won 6% of the vote in the election, now asks this court to set aside the results of the election due to various perceived infringements on his constitutional rights. There is no merit to petitioner's claims. The petition should be dismissed, both for its failure to state a claim upon which relief may be granted, and in light of petitioner's unreasonable delay in bringing his claims to this court. Argument 1. Petitioner fails to state a claim against the Minnesota DFL party for which relief may be granted. The substance of petitioner's claims against the Minnesota DFL party are best described on page 31 of the petition. Petitioner asserts that systematically applying Minnesota Statutes 202A.16 caucus, who may participate in vote, subdivision 1, eligible voters, together with the DFL constitutional provision, Article 3, General Rules and Policy, Section 1, Outreach and Inclusion, to endorse, in this case, Representative McCollum as the DFL candidate in the primary and DFL nominee in the general election, violates the First Amendment of the U.S. Constitution, and so the practice violates the Constitution, in particular political association, individual political speech protections of the First Amendment, and equal protection of the 14th Amendment. That idea of eligible voters, meaning just that somebody has voted or intends to vote in the next election, is qualified. Subdivision 2 is agreement with party principles. Only, and this is referred to by the DFL and is very brief, that you have to agree with party principles. Only those persons who are in agreement with the principles of the party as stated in the party's constitution, and who either voted or affiliated with the party at the last state general election or intend to vote or affiliate with the party at the next state general election, may vote at the precinct caucus. So these are the eligible voters. Those who do not agree with these quota principles are not eligible voters at that caucus, together with the DFL constitutional provision, Article 3, General Rules and Policy, Section 1, Outreach and Inclusion. I am not allowed to associate with DFL voters based on issues and positions, but only with delegates selected based on their gender, race, or other suspect classifications. It is not necessary for the state to do this to give the kind of equality to voters. And in fact, enforcing these quotas undermines that very goal of equality and free expression of all voters. I cannot vote or participate because I strongly disagree with the so-called principle expressed in the DFL Constitution. It must be struck down for violating the First Amendment made applicable to the state by the 14th Amendment. Petition Act 31. As a preliminary matter, because he has not alleged that he either sought the endorsement of the DFL party or attempted to participate in the party's precinct caucus, petitioner lacks standing to challenge the party's endorsement process. Moreover, petitioner's allegations relating to the DFL party do not arise from any error, omission, or wrongful act relating to an election which has occurred or is about to occur. In footnote 1. Minnesota Statute Section 204B.44 allows an individual to file a petition with any judge of the Minnesota Supreme Court for the correction of, quote, A, an error or omission in the placement or printing of the name or description of any candidate or any question on any ballot, B, any other error in preparing or printing any official ballot, C, failure of the chair or secretary of the proper committee of a major political party to execute or file a certificate of nomination, or D, any wrongful act, omission, or error of any election judge, municipal clerk, county auditor, canvassing board, or any of its members, the Secretary of State, or any other individual charged with any duty concerning the election. Minnesota Statutes 204B.44 out of footnote 1. And therefore, are beyond the allegations, are beyond the scope of alleged wrongs which may be addressed through a petition to this court pursuant to Minnesota Statute Section 204B.44. However, even if this court had original jurisdiction, which of course it does, to hear petitioner's claim, petitioner fails to allege a violation of his constitutional rights by the DFL party. Well, the violation of the constitutional rights is by the state and the Secretary of State in enforcing these unconstitutional provisions as a matter of state law and undertaking state action in the midst of elections to do so. Therefore, the state is violating the Constitution by allowing this to go on in the endorsement process of the DFL party. And Representative McCollum did serve in the state legislature and I believe was involved in voting for this arrangement, and she's also a very active member of the DFL party, benefits directly from this. So, first, they argue, the DFL party has, quote, the freedom to associate for, quote, common advancement of political beliefs, unquote, which necessarily includes, quote, the freedom to identify the people who constitute the association and to limit the association to those people only, unquote. That is from a Wisconsin case, a case involving Wisconsin. Democratic Party of the United States versus Wisconsin, 450 U.S. 107. That's from the U.S. report, so it's the United States Supreme Court case from 1981. It's quoting Cusper versus Ontiquez from 1973, another U.S. Supreme Court case. So I will raise the issue right now. When they can limit the association to those people only, does this case say that they can limit it according to their gender or according to their race or any other classification other than people who constitute the association? Does this give them the right to, for instance, say, we're only going to allow whites in this party in an area where that party is electing the government? I don't think so. To go on, they say, as the United States Supreme Court has recognized, quote, inclusion of persons unaffiliated with a political party may seriously distort its collective decision-making, thus impairing the party's essential functions, and that political parties may accordingly protect themselves, quote, from intrusion by those with adverse political principles, unquote. And that is also from the Wisconsin case, and this one quotes Ray versus Blair, another U.S. Supreme Court case from 1952. Again, these are principles that you can define who is going to vote to endorse a candidate who's going to become a member of the House of Representatives from that endorsement in a safe DFL district because of their gender or their race, and that anybody who doesn't believe this is not American enough, even if they voted for the DFL in the last election or intend to do so in the next election, if they can participate in a free and democratic party that represents the people of the United States. This is exactly the kind of thing that George Washington warned us against when he said to stay out of the partisan politics which they had seen in Europe. Okay, they go on. The fact that petitioner does not agree with the principles of the DFL party and as such is not eligible to participate in the party's precinct caucuses does not give rise to a constitutional violation. The irony of petitioner's claim is he is being denied the right to, quote, associate with DFL voters based on issues and positions, unquote, is that while he has suffered no constitutionally protected harm by being excluded from party activities based upon his fundamental disagreement with its political principles, they say these are political principles, granting his requested relief would substantially harm the DFL party's freedom of association guaranteed by the First Amendment to the United States Constitution. I don't see how. Second, although petitioner alleges that the caucus and endorsement process violates, quote, individual political speech protections of the First Amendment, unquote, he fails to make any allegation that the DFL party has precluded petitioner from engaging in any constitutionally protected speech or otherwise impinged upon his First Amendment rights. Absent some factual allegation supporting a legally cognizable claim, the petition must be dismissed for failure to state a claim upon which relief may be granted. And this is about the conduct of Mark Ritchie, who's a member of the DFL party, who is the Secretary of State and acts under color of law, operating with all the power of the Chief Election Officer in the state. He upholds this unconstitutional arrangement that limits white males to 35% of the delegates at every level of the Democratic precinct caucuses all the way up to the state convention. And this isn't just for endorsements, it's for every decision that's taken by the party, because that is where all the party power lies, in the convention. And so he cannot allow this, and he also, as the rest of this case shows, step in and stop me from communicating these kinds of facts in the election to the 383,000 registered voters through the email addresses that they provided, that he holds and that I have a constitutional right to use in order to address the core political issues in the heat of a campaign for Congress. And therefore, I say that Betty McCollum represents a DFL quota. She is endorsed by the DFL women, not by even the DFL, and so she falsely claims that she is endorsed by the DFL when she's not, and cannot be, since that endorsement process has been broken down by the state. McCollum says she wants to fight for voting rights, but her party setting quotas for blacks and whites. She says she's representing all of Minnesota, but she really represents a Democrat quota. Up here we've always talked about integration, but today we're spreading quotas all across the nation. So instead of an intelligent conversation, the Democrats use cynical manipulation. Make it count. Let the voters govern. Our democratic system makes you the sovereign. Any kind of gender or racial steering is just another form of social engineering. We need a social system that's just and fair. A quota system just gives you a musical chair. The Democratic Party doesn't want your idea. They just want you to sit there for the world to see. Make it count. Let the voters govern. In our democratic system, you know you're the sovereign. To close the unemployment and learning gap, you don't just hire performers to sing and rap. You've got to get employers to make some jobs. Not smiling politicians and their adoring mobs. Does anyone even know where jobs could really come from? Well, it's not from Keith Ellison or Betty McCollum, but make it count, but make it count, but make it count, but make it count, but make it count.